to talk about, the last part, how we sustain the momentum after the Zondo Commission, as well as, reflections on establishing a national alliance on corruption. Am I audible? Mawatu, can you hear me? Okay.
Yes, I can hear you. Can we just ask for an indulgence of about 5 minutes so that I'm on the phone with one of the speakers they're trying to connect?
Okay.
Thank you.
Thanks, Mabatu. So, colleagues, can we just give us then 5 minutes to get one of the speakers connected before we start? We apologize for that. That means I must give up my opening remarks, but we'll catch up down the line. So just give us a few more minutes, then we'll start. Mabatu, please kindly advise once the speaker is connected. Thank you.
I'll do so, CEO.
Okay, colleagues, I think we'll have to start
CEO, sorry to interrupt. Mr. David Lewis is there. He's just in the attendees list. So can I just ask the host, I think it's Giver, to just unmute him from the list?
Thank you.
So he is here ready to present.
Okay.
Thank you.
But he can hear us. Okay. Thank you, colleagues. We have taken 5 minutes of the opening address of the chairperson. So yes, welcome. As I was saying, this is day 3 of the conference. And really today it's about us reflecting on the current anti-corruption bodies and the effectiveness in dealing with the issues of corruption, but also an opportunity for us to reflect, what more can be done by all of us as a country, as institutions, to better fight the scourge of corruption and its impacts on human rights. And of course, we as a Human Rights Commission later on will also be discussing how we can help to build a national alliance or national coalition of all relevant stakeholders in basically fighting, preventing and combating corruption much more effectively than we are doing currently. Can colleagues please mute? I hear background noise. And therefore will also be proposing ideas from our side as to how this can happen. we are certainly, as a commission, in partnership with our colleagues in Public Protector, committed to making sure that we get more involved, because as we were saying earlier on, corruption does affect human rights, and it is a business of us as a human rights body, as a South African Human Rights Commission. So without taking much time further, I will then hand over then to Mr. David Lewis. I see he's now on the screen to talk about, the challenges really around, the enforcement of the Protected Disclosures Act in protecting whistleblowers, and what are some of the challenges and gaps around this legal framework, because it's very clear that we cannot effectively combat corruption in our country if many people who witness or experience acts of corruption are afraid to come forward because of the victimization, which some of them incur. As we've heard from Mr. Zulu's testimony, there are still these problems, but there are also some inherent weaknesses in the legal framework. We, as a Human Rights Commission, last year went to court around the issues of witness protection. And I can assure you, colleagues, we had major problems in trying to get witness protection for Mr. Zulu. And once he got it, it was definitely not appropriate. And we're seriously considering, as a commission, whether we should actually push for further amendments, even for witness protection, because as a human rights defender, how then do you get protected when your life is at risk for simply doing what is important for us? So we do need to also scrutinize the legal framework as to whether it is actually conducive in us fighting corruption much more effectively. Mr. David Lewis, over to you.
Yeah, thank you, Chair. In the limited time available, let me just make a few points. I mean, the Corruption Watch model is deeply rooted in whistleblowing. We call on the public to provide reports of corruption to us, and this they do at the rate of about 100 reports, slightly over 100 reports a week, and we have done this for a number of reasons, partly because the reports are valuable. They're valuable intelligence. They allow us to derive patterns of corruption. They give the whistleblowers some outlet for reporting corruption where they can trust. Certainly their reports are not going to be revealed, or their identities are not going to be revealed, but we don't promise to investigate all of the reports. We can, in fact, only investigate a tiny fraction of them. But as I say, they do allow us to identify systemic corruption and patterns of corruption. And they also establish our legitimacy, because when we speak and when we provide the public with information that there is a corruption problem in a certain school's district, for example, we don't suck it out of our thumbs. We have, 200 reports to verify what it is that we're talking about. So we're deeply rooted in corruption, in whistleblowing, and we want to make the point that whistleblowing is, as the chair already said, absolutely essential if corruption is to be combated. This is a crime that is usually between two consenting criminals, two consenting partners. And it's not like an assault crime or a murder crime where there's a dead body or an injured body. Nobody is injured except the public, and unless some member of the public is willing to spill the beans, you're not ever likely to find out about the crime, let alone combat it. But I just want to make 3 points. The first is that there are whistleblowers and there are whistleblowers. The tendency, particularly of conferences like this, is to view all whistleblowers as heroes who have done what they have done because they are morally offended by what it is that they have seen. That's not always the case. There there is a spectrum of whistleblowers that start with, if I could put a name to it, the Cynthia Stimples of this world, the SAA whistleblower, who blew the whistle right as she saw the corruption because she was morally offended by it. At the other end of the spectrum, there's Angelo Grisi, who blew the whistle not, as he said, because he found God or because he found a moral compass somewhere, but because he feared that he was falling out with his co-conspirators, that the police were closing in on them, and that his co-conspirators may attempt to finger him as responsible for all that Bosasa had done. And so he got in before they did and blew the whistle on them. But he's a thoroughly corrupt individual. I mean, he certainly has been a thoroughly corrupt individual. But his testimony is very, very important. I mean, in essence, in exchange for immunity from prosecution or for a reduced sentence, he will knife his co-conspirators. He will rat on his co-conspirators, and in many cases, his testimony is more valuable than that of the more heroic whistleblowers who do this because they're morally offended by what they've seen. He's been right in the room. I mean, as anybody who saw Grisi's testimony at the Zondo Commission, he was there when the money was counted. He filled the bags with money and took them along to various ministers and the like. And so the testimony he gives, if you want to convict some other high up involved in his corruption conspiracy, is absolutely invaluable. We've seen that now in the VBS case, there is an insider who has blown the whistle in exchange for a reduction of a sentence to 7 years, which tells you something about how serious his offences must have been if all he's managed to get is a reduction to 7 years. There's the whistleblower in the Bosasa thing who is a Grisi, and I think that there might even be a whistleblower in the Free State, infamous Free State asbestos case. So that's the first point that I want to make, is that all whistleblowers are valuable, but not all whistleblowers are moral heroes. What one does with that information, I'm not entirely certain, but it is important to bear in mind that you have to bite your tongue and welcome the Grisis and whatever into the company of whistleblowers because of the value of their testimony, not because you are engaging with a fellow kindred spirit who abhors corruption. The second point that I want to make is that corruption is a special form. There's a particular form of victimization. Victimization is an offense that we know very well from labor relations experience. It's effectively where you are prejudiced at work. Let's say you are fired, not for something that not for the offense for which you have been identified to have contravened, but you really have been fired because you have organized a trade union at work, or you have led some kind of opposition to the employers, or you have blown the whistle on corruption. So it's a special form of victimization that is covered not by the Labor Relations Act, but by the Protected Disclosures Act. And any trade unionist will tell you that victimization is an extraordinarily difficult offense to oppose, because unless the boss is really stupid or naive, he or she will have found some ostensible reason for having dismissed you. They won't say you're dismissed because you blew the whistle. They won't say you're dismissed for having organized a workers' strike. They will say you have been dismissed for persistent late arrival at work, or because you were insubordinate to the foreman, or whatever the case may be. And you are then faced with an extraordinarily difficult and complex litigation process where the facts are in dispute. And so it's a sort of he said, she said kind of exchange where they will come forward with some ground for having dismissed you that is not the real ground. And so the litigation is lengthy, it's expensive, it's time consuming, and in general, it's a horror story as far as litigation goes. And the third thing to say, and this goes, I suppose, to the heart of our conversation today, is that legislation doesn't help a lot. It really doesn't. I mean, for all the reasons that I've laid out here, of course, one has to have legislation that declares victimization an offense, or that declares the kinds of conduct covered by the Protected Disclosures Act an offense. And of course, the Protected Disclosures Act could be strengthened. I mean, it's not terribly different from any legislation of this sort anywhere else in the world. In fact, it's probably stronger than many, but it's weaker than some. You know, for example, the most glaring weakness in the Protected Disclosures Act is that it only covers employment-related victimization, employment-related discrimination, and there are other forms of victimization. I mean, ranging from, you know, assassination to you know, some employment-related punishment through to assault. It's all there. I mean, in the more dangerous forms of victimization, a witness protection may be called for and is called for, but nobody should imagine that witness protection is fun. It really is not. It's something you want to go into only as a last resort. You are required to change the place that you live, to not engage with your family, even members of your family or close friends. Nobody must know where you are. And it's not a choice that one happily accepts. But there are prejudices. For example, suppliers often detect victimization. Competitors often detect whistleblowing discrimination. Competitors often detect whistleblowing discrimination, and all of these other categories, other than employees who blow the whistle, may suffer some prejudice. If a supplier detects it, the company will cut that company out of its supply chain panels, and the PDA, the Protected Disclosures Act, should extend to those as well. The PDA could also give organizations like ourselves, like Corruption Watch, more standing as parties who can receive protected disclosures, and it's something that we want to do in the future. But for the reason that these are often, as I said in making the previous point, factual disputes with very difficult litigation path ahead of one, the law doesn't help a hell of a lot. And in fact, what you want to do is work yourself into a situation where whistleblowers are treated as heroes, where they're celebrated, where the president writes them a letter thanking them for blowing the whistle, where they get awards from the state for blowing the whistle. You know, whistleblowers are still often treated as impimpies in this country, and they're anything but. In fact, they should be treated, particularly those who are really heroes, should be treated as heroes. The rewards a greasy gets is a reduction in his potential sentence. But the reward that the likes of Bianca Goodson or Cynthia Stimple get is to be dismissed from their employment and to find it incredibly difficult to find employment again. And so, I think that a more effective way of protecting whistleblowers is, as I say, to make them heroes, to set up support groups of whistleblowers. Cynthia and one other whistleblower who was treated, I think, very badly, Suzanne Daniels from ESCOM, have set up, or in the process of setting up, an organization that will be a support group for whistleblowers. The National Anti-Corruption Strategy also proposes the establishment of an agency specifically designed to protect whistleblowers, which I hope may include funds for the very expensive litigation that they have to go in. So, just as the trade unionists discovered that the only really effective instrument against victimization for joining a trade union was worker action and worker solidarity, so too do the whistleblowers need an organization that is able to defend themselves, to defend them. They won't be able to do it the way the trade unionists did it, by ultimately threatening to go on strike or actually going on strike. But there are ways of supporting them through publicity, through, as I say, making it clear what heroes they have been, and through support for litigation. Psychiatric support is very important. I mean, whistleblowers are often extremely damaged by their experience. So really, that's what I want to say. So I'm afraid if you were expecting a detailed account of the PDA and examples of where it could be tweaked, you're not going to get that from me, partly, as I've said, because I think it is, more or less consistent with whistleblower protection legislation everywhere, but also because I don't think, even if it were strengthened, and we've advocated the strengthening of it consistently, I don't think it's a particularly powerful weapon. So thank you for that.
Thank you, David, for your very enlightening contribution. And also thank you for the work you've been doing up until now. Certainly, there is a need for us to do more in protecting whistleblowers, but also encouraging them, because without them, really would not go very far. Those of us who come from the criminal justice system world, we know that most crimes in our country can only be solved through the involvement of the people, and not only the police and law enforcement officers. Our next speaker will be Dr. Peter Moons, but from a business community perspective. However, just before I allow him on the floor, I just want to highlight one example, David, which you talked about, that we were dealing with someone from the business community, and giving us some information about some of the challenges around corruption. And the issue was, can you then come forward? The person says, well, I could, but I will then be blacklisted. I'll not even get a single tender anyway going forward, or a business contract. These are some of the issues which we have to find a way of addressing as a community and as a collective. Dr. Peter Moons, over to you.
Hello, Taliso. Good morning. Can you hear me?
We can hear you.
Thank you, Taliso. Thanks very much for the invite onto the panel. I think that the last 3 days have been the last 2 days have been informative, and I think that the Human Rights Commission has got a very important role to play in going forward. The most important thing that we have learned over the last, especially yesterday, was the presentation on the UN Convention on Corruption by Jean Procwa. Now, the interesting thing here is the definition of corruption, which is the abuse of entrusted power for private gains. And it doesn't matter how you sugarcoat it, whether you call it bribery, trading in influence, illicit enrichment, abusive functions, embezzlement, or mismanagement, the impact of corruption is definitely a human rights abuse. In fact, what it is that it's treason at its worst level. I think that what we need to do is to have really take a jaundiced and a view and a clinical look at the situation that we have in South Africa. And we really need to be paranoid. And paranoid is defined as being able to connect the events that are seemingly unconnected. We've had the last 27 years to establish
Peter, are you there? Peter?
Hello?
Yes, we lost you for a little bit. You were muted. Okay, I can hear you now.
Okay. I don't know where you lost me, because I don't know why it actually went on to mute.
Just half a minute, but you can continue.
Okay. What I would like to say is that we've had the last 27 years of being able to have a museum of truth and a library of evidence. And that's, sorry, I'm actually losing the signal here. So Lisa, can you hear me?
I can hear you. I'll let you know if I don't hear you.
All right.
And can,
thank you.
sorry, can Professor Lumina please mute as well? There's a background coming from you.
I think that might be some kind of interference.
Professor Lumina, thank you. Please mute. Okay, Peter, you can continue.
Okay. I think that where we have been with the business chamber is that we've had a tremendous amount of time to do meticulous research, careful planning, and patient preparation. And I think that what we've seen with COVID-19 is the perfect opportunity to establish some kind of national alliance and an advisory council that was discussed yesterday. I think that what we have to have a look at as well is that the consequences of this corruption that has taken place, especially over the last 10 years, where we've, it's all about rule of law and it's all about law and order, and there's absolutely no sign of this. And where we have a constitutional and political crisis in the country at the moment, as a result of people, the former president, actually going about opposing, even defying the law itself and the rule of law. And if we have a look at the Helen Suzman Foundation, summed it up on the 25th of this month by saying that South Africa is facing a unique threat to the courts and also to the administration of justice, and also a threat to the rule of law.
You're faded, Peter.
Hello, can you hear me?
I can hear you now.
Hello. Okay. South Africa is facing a serious crisis. It's a constitutional and political crisis in 2021. And it's probably the biggest crisis since 1994. And we need courageous and wise leadership. It's needed in government. And I mean, if we have a look at what has happened with the former president ignoring the Constitutional Court, he's ignored the rule of law, and the UN Convention on Corruption is clear. The entire strategy to fight corruption is based on the rule of law. Now, the strategy depends on good governance, and this is a threat to the Constitution and the rule of law. So we need peace and we need that freedom, and the plan of action is needed to achieve this. But the integrity of the judicial system is key, and South Africa needs the integrity of the justice system. The Peace Commission is needed in 2021. More than $33 billion has been siphoned from the state coffers, and South Africa needs freedom from this corruption. So South Africa needs that rule of law, law of order, and it needs an alliance of those people in civil society, both in the public and private sector, to do something about what has taken place in the last 10 years. So corruption is a crime against humanity, and it's certainly a crime against human rights. It's an abuse of human rights. And the economy is in junk status, it's in recession, and we need economic certainty. We also need political stability. But most of all, we need investor confidence. And South Africa needs a peace commission. It doesn't just need a human rights commission, but it needs a peace commission because things are lawless. It's an economic battered, or the economy has been battered by the pandemic, but it also has a recorded high unemployment rate. And South Africa needs wise and courageous leadership and alliance and coalitions to do something about this. The mass protests that are threatened now to destabilize the country as the result of the New York Times predicting civil unrest on the 25th of March. It warned of these protests. Political instability threatens the economy. South Africa already has junk status and a recession. In 2019, we were rated by the ranking agencies of Fitch, Moody's, and Standard & Poor's. That was before the corona pandemic. South Africa needs a vibrant economy. There are 34 business chambers that are needed to intervene. Captains of industry, mind leaders in commerce need to participate. There are 34 main sectors of the mainstream economy to get involved. South Africa needs these rule of law and law and order if we're going to have that stability and also that investor confidence. So South Africa needs a peace commission as well, where people are actually going to be totally committed to bringing about a peaceful resolution while corruption is being fought. Now, corruption as well.
1 minute, Peter. 1 minute,
Okay.
1 minute.
All right. The Human Rights Commission has got our full backing on this. The Universal Declaration of Human Rights should be our guideline, the 1948 Universal Declaration of Human Rights. South Africa's got a constitution, it's got a Bill of Rights in Chapter 2, it's even got the Human Rights Commission. But now we need to join hands, hearts, and minds in making sure that we have a national alliance. We have an anti-corruption council that is an oversight committee to the Zondo Commission and also this anti-corruption tribunal circus that was established and has actually achieved nothing since 2018. So we need to be passionate about it. I think from our side, we're extremely well researched. We're not just agonizing over the problems and the issues and tissues, but we're totally committed to finding a solution to this. We have a strategy, and we look forward to going beyond this and just being a panel or a discussion. We'd like to engage with all those people who are equally committed, and we look forward to a future of a strategy that's going to be effective and efficient in dealing with this plague in this country. Thank you, Tshilisa.
Thank you, Peter, and welcome for your contribution and suggestions, and of course, your commitment to work with all of us. C.S. Lewis says, you are never too old to set another goal or to dream a new dream. 25 years in our country, certainly we can still have new dreams in fighting corruption. Thank you.
Amen.
Our next speaker will be from the Public Protector, Advocate Niels van der Merwe, a good friend of the Commission. He will talk about, the role of the Public Protector and the perspective towards the future endeavors in fighting this scourge. Neil, you're on the floor. Niels.
Good morning, Chair. Good morning, colleagues. I'll stop the video because of the bandwidth. Yes, from the Public Protector, we are grateful for this opportunity, and we think it's also I assume that you can all hear me, unless people are saying that I'm not.
We can hear you. We can hear you, Chief.
Okay. I think this is a long overdue and well received opportunity. I was thinking this morning, because over the weekend I read about the richest people ever in the world, and there's been only 6 people ever in their history that can be called trillionaires. People like Julius Caesar, Genghis Khan, and I don't even know how many figures there are in a trillion. But I was thinking that if, corruption was a person, it would have probably been the richest person on earth. And what bothers me is, unlike the George Bezos, Elon Musk, and Bill Gates of the world, corruption has not accumulated this wealth through a positive impact or making a positive impact on the lives of people. It does have an impact, but on the most vulnerable, the most severe. I think of the lady on the corner in the mornings when I go to work that I had to wake up at 4 o'clock to bake some vetkoek, or the person that in the informal settlements that can't cook when it rains because he has to use all his containers to catch up and keep the rain out of his house, or the person and the lady in the queue seeking healthcare, and those are the victims of the money that the government is spending on improving the lives or making the constitutional dream possible. And it is not doing that for the people that matters the most. From the Public Protector side, our constitutional mandate is derived primarily from Section 182 of the Constitution, that gives the Public Protector the power to investigate any conduct in state affairs and in public administration that is improper or causing prejudice. The anti-corruption mandate specifically is also derived from Section 6483 of the Public Protector Act, which mandates the Public Protector to investigate any improper or dishonest act or omission of offences referred to in the Prevention and Combating of Corrupt Activities Act. And also the Prevention of Organised Crime Act, the Public Protected Disclosures Act, PAIA and PAJA are part of the legal framework that supports the efforts aimed at combating corruption within the mandate of the Public Protector. In addition to that, and it's something that the Public Protector has been saying all over for the past years. Next year I'm here for 25 years, and I think apart from Advocate Selby Bakwa, every Public Protector has been saying that there's about between 13 and 16 additional pieces of legislation, including the Executive Members Ethics Act, the NHBRC Act, Information Regulator, the National Energy Act, improper conduct relating to environmental management, Public Finance Management Act, Lotteries Act, Archive Service, Electoral Commission, that all contributes to the mandate of the public protector, expands the mandate of the public protector. But one of the challenges is these functions have never been properly costed or funded from on the side of the public protector. When the public protector deals or encounters in the course of her investigations, comes across corruption, she deals with it as part of the maladministration mandate, except in the case of Executive Members Ethics Act, which is a specific mandate to deal with contraventions of the Ethics Code. The Public Protector Office is also set up in such a way that when we deal with complaints, and I must add, the mandate of the Public Protector implies jurisdiction and oversight over more than 1,000 organs of state. That's on national level, provincial level, local government level, and in all the statutory bodies, universities, you can name it. At the height of the office's, I won't call it credibility or the demand, a few years back, the most number of complaints we received in a year was 38,000, which sounds like a lot, but coming from oversight of 1,000 organs of state, we are barely scratching the bottom of the barrel in trying to make a difference in a reactive response to complaints and to investigations on an individual basis. That's why the foresight of the Human Rights Commission on this issue, to do something to be proactive and to have an impact not only on the people that approaches the public protector on an individual basis, but everybody that can benefit from the advantages of an anti-corruption strategy, the investment, the development, healthcare, everybody in a proactive manner, that is unmeasurable in terms of the value, because even in terms of the budget reductions that Treasury has announced, we have to plan and carefully allocate resources to the kind of cases that we are dealing with. And it becomes more and more evident that we have to focus on the wider victims as well, the communities, the vulnerable people, in dealing with systemic issues. And corruption is probably one of the biggest systemic threats there is in terms of the work that a public protector is doing. Generally, a few years back, we did a survey because our office is set up in units that deals with, on the one hand, what we deem service failures. Those are the inordinate delays, the ID documents, the municipal queries. And then on the other hand, what we would call conduct failure. Those are unethical issues or issues of integrity raised in connection with public servants. These days, we have a spike in complaints relating to irregular appointment, where it's not innocent, where there's allegations of nepotism, contravention, deviation from policies, and in the end, irregular expenditure, because the person who is appointed in that position who can't do the work is being paid the salary while not delivering a service. The other big topic for investigations from our side is public procurement, where there's enormous amounts of money spent on contracts. And what bothers us, it happens under our watch, right before our eyes. The recent events around the 300 million rand for the artists, it happens on our watch. The state capture, I mean, the amount of money that is lost through people that are not even, it's not even just bad governance, it's criminal acts. is enormous. Then the other focus area of the integrity unit is, of course, executive ethics, where the public protector has a mandate to deal with contraventions of the Executive Ethics Act. A few years back, we did a survey. About 50% of our complaints constituted unethical conduct, and about 70% service delivery conduct. But the unethical conduct reports tend to take most of our work, and it also ends up in most of our reports. The public protector has the powers in terms of the legislation to take binding remedial action, but the biggest threat currently is the fact that the impact that a public protector has, the mandate and the powers of the public protector, is the very same people who are implicated in these offences, in these activities, have unlimited access to public resources to challenge and take the public protector on review. So, and a lot of our cost goes into legal costs at the moment. And what the state and people out there tend to forget is that in the end, the person that suffers when the public protector suffers a defeat in court is not the public protector per se, but it's the persons who are dependent on our organizations, the Chapter 9 institutions, to make a difference in their lives. And in the end, it's public money that's spent on an investigation, public money that's spent on the litigation against that investigation, public money spent on the defense of that investigation. Then if the whole report investigation is set aside, it doesn't make fiscal sense that there's no benefit for the man on the street. We can't make a difference. Then lastly, we support the integrated approach for the combating of corruption and the promoting of ethical conduct, as now proposed by the Human Rights Commission, from my side at least, because we don't have proper reporting structures. We want to know what's the impact of corruption, what is the impact of whistleblowing failures. We don't have a complete database. And the advantage of such a collaboration would be an enhanced public profile. We don't have someone that can speak up and say, the National Development Plan says that the public protector, the anti-corruption agencies, Human Rights Commission, everybody must get more money to strengthen their anti-corruption arsenal. But if it doesn't happen, there's no consequences, there's nothing to speak. The specialization, concentration of anti-corruption expertise is essential. Independence and integrity, we see the cases of political intervention. The show of a political will on the part of government to put billions of rands into and it's not going to be coordinated, and it's not independent and with the necessary integrity, is going to be a waste of money. Then sorry, my time is up. Resources and capacity to, in the time where we are now facing severe budget constraints, it's essential that we pool resources and expertise, but also adequate powers, an enabling environment, and effective coordination and institutional clarity is needed to make such a body work. Thank you, Chair. I think my 10 minutes is up for now.
Thank you, Advocate van der Merwe, for coming in as a late substitute. Definitely the issues, the importance of collaboration between all of us, it's really important and vital for us to make headway in this struggle. Our next speaker, it's supposed to be Miss Kale Pillay. I got a WhatsApp that she might be struggling to link up. Babatu, is she in now?
CEO Sunel Brewer is here on her behalf. Sunel, on your side, if you can just click on share up top on your screen, you can share the screen.
Okay. So is Ms. Sunal Brewer the one who's going to make the input from the Department of Justice?
Yes, CEO.
Thank you. Ms. Sunal Brewer, you have the floor, and kindly tell us who you are. Thank you. Please unmute Ms. Brewer.
Good
Thank you.
morning. Good morning, sir. Good morning, panelists and all participants. My name is Sunal Brewer. I'm one of the members of the National Anti-Corruption Strategy Steering Committee, and I've been caught slightly unawares of this engagement due to the challenges that Advocate Pillay is suffering. So I'm going to try to share my screen. Maybe one of the technical people can just talk me through exactly how to do that. I'm really sorry for that. She said share screen, and then she said I should be able to do it, but I've not worked on this platform before. I'm not getting a share screen functionality. I'm very sorry.
So if you look up top on the screen, so as you're viewing the screen, on top of the list of participants on top, there's file, edit, and share.
It's not allowing me a share
It's not
function.
allowed. Are you able to quickly send me the presentation so I can share it on your behalf? I can send you the email now on the chat.
I will do that. I will do that. Apologies
Ms.
for this.
Brewer, you can also just speak to your slides, then we can have them later, if it's possible.
All right, I can.
Sure. It won't be a crime if you don't see them
It
now.
won't be a crime if you don't see me now. All right, let me see if I can start a video, and at least you can see my face. Have you got me on video? Not yet. All right, then I'm just going to talk. Seems like I've got some technical challenges. All right. With regards to the question that was posed to the DG of Justice, it deals with the institutionalization and institutional arrangements that will be required going forward. Now, I note that Mr. David Lewis is here, and I note some of our other colleagues from the steering committee was also here. So just perhaps a little bit of context, and I think most people would be aware of that, but the National Anti-Corruption Strategy was unanimously approved by Cabinet on the 18th of November last year, and strategy implementation has already commenced, and it is very clearly stated that participation from and collaboration from all members of society will be required. Now, there are still further developments in terms of implementation that's taking place. And as announced by the President in the State of the Nation address in February this year, there will be some institutional arrangement changes that will take place. Now, the strategy essentially will be implementing across 6 pillars on 7 strategic objectives, which deals with citizen participation, ethical leadership, professional skilled employees, transparent and accountable governance systems, creating a culture of reporting and whistleblowing, protection of all sectors most vulnerable to corruption, and then the strengthening of anti-corruption agencies. A lot of collaboration is required, and as the strategy was drafted with all constituents consulted on this, key stakeholders are still called upon to form a coalition to assist that we achieve these goals of the strategy across all sectors of society. Now, we've done stakeholder mapping in that regard, and now I get to what you would like to know, that the National Anti-Corruption Strategy adopts a 2-phase approach for implementation, and there will be some need for urgent interventions which are recognized and prioritized for immediate parallel rollout. The strategy term runs from 2020 right up to 2030, and there is a section that deals with these implementation measures. As a transitional mechanism, a National Anti-Corruption Advisory Council will be put in place, and this council's terms of reference is currently with the President for his sanctioning and approval, and then for facilitation of the appointment of the council. And then the second element, which he also announced and which caused a bit of confusion at the time, is that the ideas are for a long-term institutional arrangement, and it is proposed that a proposal in that regard be drafted for Cabinet to deal with that. So there are many opinions about institutionalization and these institutional arrangements, but the idea is firstly the long-term body, an independent, overarching, statutory or constitutionally entrenched state body that will report to Parliament. And this long-term body is premised on the integrated multi-agency operational model, but specifically with cross-sectoral collaboration in line with the country's whole of government and societal approach to combating corruption. Now, as indicated, we have a transitional phase moving us towards that, where the initial implementation, in other words, the phase that we are now in, where the steering committee and what we have as the reference group, which has supported us through this process, needs to hand over to the council. So the advisory council will now come into play. The question around the interfaces with other institutions, all existing law enforcement institutions, including the Hawks NPA, the Special Investigating Unit, will continue as normally with their legally mandated work, as well as the Anti-Corruption Task Team in this transitional period. Now, the long-term body will specifically drive the long-term rollout of the strategy and all its related programs over a period of 10 years. The long-term anticipated body will report to Parliament, and as indicated, it's premised on an integrated operational model. However, in this transitional phase, the National Anti-Corruption Advisory Council will be responsible for managing the strategy implementation, and then very specifically including research and the conceptual development and drafting of a proposal for Cabinet for the establishment of this long-term overarching body. The National Anti-Corruption Advisory Council will conduct its work through engagements with the relevant interministerial committees, the clusters, and the various social partners. Now, the National Anti-Corruption Advisory Council will be established by the President, and it will be broadly reflective of the South African society. The membership of the Advisory Council will be drawn from the government, civil society, business, labor, media, and academia sectors, and a government representation on this Advisory Council will be at a minimum. There will be consideration of some ad hoc government participation on an ex officio basis, which will include representation of the host department. Now, the designation at the moment is that the Department of Planning, Monitoring and Evaluation is responsible for the setting up of the council, and it also provides then for chairperson of the ACTT in terms of government representation. Now, the National Anti-Corruption Advisory Council will operate for a minimum of maximum of 2 years, or until such time as this permanent new body is established and operational. The rationale around the 2-year period is that it allows for the legislative proposal and the required structural arrangements to be put in place for a long-term body. Now, nominations for the council will be requested through a call through national newspapers, and then these people who will be nominated need to provide CVs, and the nominations that will be required will then be considered by the National Anti-Corruption Strategy Reference Group, and they will put forth a couple of names, or at least 15 names, to the President, from which the President will then choose the members of the council. So there will be civil society oversight in terms of who will be appointed onto the council. Now, the anticipation around the council in its transitional format is that it will consist of about 7 to 10 members, and that the President shall designate a chairperson from these members. The members of the National Anti-Corruption Advisory Council will be appointed in their individual capacity based on their professional profiles, past experience, and their contributions towards ensuring an ethical society. And they will then be stationed for the period of their services at the Department of Planning, Monitoring and Evaluation who would be hosting them. The National Anti-Corruption Advisory Council will also be supported by a full-time dedicated secretariat that will be established at the Department of Planning, Monitoring and Evaluation, and who will assist with the facilitation of the execution of the Advisory Council's mandate. The Council will also be able to establish and convene working groups as and when required, and those members will not necessarily be part of the National Advisory Council, but they can be called upon. And that is where the expert participation from the academics, the people from civil society, the private sector entities would be requested. Now, in terms of the interfaces, the National Advisory Council will firstly work through the Department of Planning, Monitoring and Evaluation, and there will then be mechanisms in place for them to engage with the relevant parliamentary committees if necessary or when called upon, and they will report on a quarterly basis to the President in terms of the work that they have done. And I hope, without the aid of my visual presentation, that I have covered sufficiently what had been required. Thank you very much.
Thanks, Sunel, and thanks for stepping in at a very short notice. May I ask, do you have time or for later discussions, or you have to leave now? And if you are leaving now, can we then allow just a few minutes of questions of clarity?
I have to attend another meeting at 11 o'clock, so I am available until 11 o'clock for questions.
Okay.
Or if you want to continue with your session and then take the questions, I can avail myself
Okay.
until then.
Yeah. In that case, then maybe what we should do then is to allow, with the permission of everyone else, just 10 minutes of questions of clarity. Then we'll take a break and then continue with the program as adjusted. Is that okay, colleagues? Thank you. Okay, we'll then take just 10 minutes of questions and comments, and then we'll release you, Sunel, for your other engagements. I see we have now been joined by Commissioner Chris Nissen. He will take the floor thereafter. Okay, colleagues, any questions of clarity? This is just at the beginning of the process, so let us not have another conference on Sunel's presentation. There will be more time for discussions on that. Just really a few questions of clarity and maybe concerns which Sunel can then take forward to her colleagues. Thank you. Any questions? I don't see hands. If I don't see any hand, Sunel, can I then ask then on behalf of the Commission, what is the thinking as far as the relationship between your processes and the Chapter 9 institutions like Human Rights Commission and Public Protector? And two, if we are thinking of establishing a statutory body accountable to Parliament, will this then mean, because I've had people before, this might mean an amendment of Chapter 9 of the Constitution? Yeah, just clarify on those 2 points then. Thank you.
The thinking at this point in time is that there is full acknowledgement that a constitutional amendment would not be ideal, and that ideally the legislative proposal that will be drafted by the Advisory Council would provide the clarity in terms of, is there regulatory consolidation or legislative consolidation or anything in that regard that would be required. And I think that in the National Anti-Corruption Strategy, the role of all the various oversight bodies, the Chapter 9, Chapter 10, also in terms of the Public Service Commission, are fully acknowledged and they are respected, and that there is no intention that there will be any sort of overlaps with any of those, but that there will be the development of adequate interfaces in order to ensure that referrals, cross-collaborative referrals and participation and collaboration is very tightly cemented between any new anti-corruption mechanism and agency that comes into being into the country. And I think also, if necessary, I want to call on one of the other panelists, David Lewis, who's a part of our reference group, who's actually co-chairing our reference group, that he can step in if I'm not answering any of these adequately. I think there's, at this point in time, there is leeway that the advisory council, with its high-level council members that will be appointed, will have the task to investigate what is going to be the best possible solution in order to make sure that we optimally coordinate and consolidate the vast number of streams of anti-corruption work that is taking place across the country, and specifically also to put emphasis on a number of areas, predominantly in the area of prevention of corruption, which had been lagging in terms of also our international commitment participation in that regard. I hope that answers the two questions that you have posed. So the interfaces at the moment does allow for any sort of engagement with the existing Chapter 9s and 10s, and there is no intention to substitute any of them. And if a constitutional amendment is required, then that will be a recommendation forthcoming from the Advisory Council.
Thank you, Sunil. If there are no other questions of clarity or comments, David, do you want to say anything if you're still around? I see you're still around.
Yeah.
Yes,
Thanks, Sunil, for doing that really comprehensive presentation. I hope that we're going to be in a position to release the National Anti-Corruption Strategy publicly soon. It's held up by the mail somewhere between the Department of Monitoring and Evaluation and the Presidency. But one of the most vexed questions that we've had to deal with is the institutional arrangement for this new anti-corruption agency. And once you delve into the problems, they're not simple problems to resolve. So there's quite a strong, there's a fairly strong body of opinion in support of a single agency to deal with corruption, and for it to be a Chapter 9 institution. And once you start delving further into the issue, some of the problems with that emerge. For example, obviously critical to the whole anti-corruption effort are the criminal justice agencies, the National Prosecuting Agency and the Hawks, let's say, but also the SIU, also crime intelligence, a number of core SAPS bodies and other law enforcement or quasi-law enforcement agencies. And it's not easy to see how they would fit into a single anti-corruption agency. I mean, by the very nature of their function, you can't have an NPA reporting to another body in order to take decisions around who it prosecutes and who it doesn't prosecute. You can't have the Hawks reporting to another agency about the course of its investigations and whom it decides to investigate. And so while there's obviously going to have to be a very, very close relationship and interchange between the criminal justice agencies and the anti-corruption agency, the new anti-corruption agencies, whether they could be part of the same body or not, I'm not so confident. And whether they gain anything by being a Chapter 9 institution, I'm not sure either, but maybe they do, because there certainly will be plenty of work for the anti-corruption agency in the area of public education, public representation, policy advice, data collection and analysis. It's going to be a very busy organization. But whether there can be one single anti-corruption agency is something that I think needs a lot of discussion. And you know, I've spoken about the functional problems, but let me tell you the political problems it will create by trying to hive off the hawks from the police or a clump of the National Prosecuting Authority from the NPA is another question altogether.
Thanks, David. I guess there will soon be a need for another dialogue on this strategy and the envisaged institutional frameworks which will accompany the strategy in the context, of course, of bodies like ourselves. But more importantly, as we've been saying, colleagues, yesterday, there's definitely a need for a much more intensive human rights-based approach to anti-corruption strategies and mechanisms. And therefore, there is a need really to address these issues. Otherwise, we'll keep on continuing with what we've been doing in the past with a heavier focus on the criminal justice approach and forget the broader issues, which are really crucial for us to be more effective in how we address this. So on that note, colleagues, can I then propose we take a 5 minutes break and then we'll then get back to the next session.
CEO, there are two hands. There were two hands.
Oh, sorry. I did
So
not
the
see
first
the hand.
hand was from Paul Hoffman, and the next is from Mr. Muntz.
Okay. I guess if colleagues will indulge me, then we'll allow those two hands and delay the break by another 5 minutes. So colleagues, please be very precise on your inputs, knowing that there will be another engagement very soon on these issues, which hopefully the Commission will be part of. Thank you. Paul Hoffman,
Okay.
you have the floor.
Thanks, CEO. My question is for Sunel. I've noted that in the SONA, there was talk of a statutory body, and that in her presentation, a statutory or constitutional body. And my question to her is that if the new body is not clothed with the protection of the Constitution that flows from the independence that all Chapter 9 institutions enjoy, how will it be possible to protect the new body against the same fate as the Scorpions suffered because they did not have what the Constitutional Court now requires, which is secure tenure of office?
Peter.
Yes, much Sunel, is that in 2015, we were invited to participate with the xenophobic violence in South Africa. We visited with the Royal House, the Zulus. We also were flown around the country to participate in this development of a national action plan that took 5 years. It took 5 years. We also got very involved with the Anti-Corruption Tribunal. We respected Judge Jerome Wells to allow us to be an oversight committee of the Anti-Corruption Tribunal and the Zondo Commission. And everything seems to be centered, even with the Special Investigations Unit, the formation of these structures, these advisory councils and commissions, it all seems to land up at the desk of the Office of the President. And we have a problem with that because it doesn't have that neutrality. It cannot be seen as being an independent body, and it can't be seen as a process that is going to achieve anything if there's clearly no political will to achieve the desired results. So the question I want to ask Sunel is that what do we need to do to make sure that we don't have a repeat of the National Action Plan or getting rebuffed from the Anti-Corruption Tribunal, the Anti-Corruption Tribunal panel that was established? So we need that neutrality, and we need more involvement from the private sector and civil society. That is my question. Thank you.
Thank you, Peter. Sunil, over to you in 2 minutes.
I think you're putting me in a very difficult spot with both those two questions. To Advocate Hoffman, I think we acknowledge also his participation in some of the consultation work beforehand, and that exact question around constitutional versus the statutory was raised in that context as well, that we need to ensure that they do enjoy independence and security of tenure and all of those things. The deliberations on the exact mechanisms and exactly how that will be defined is going to be the task of the Advisory Council. And I think that is why it's of such critical importance that the nominations of members of the broader public, and specifically experts in terms of legal advice, in terms of the civil society advice on these, the humanitarian advice on all of these matters, is crucial when it comes to the composition of the Advisory Council, as they will be tasked with defining those things. I think generally there's acceptance that it should be a statutory body vis-a-vis a constitutional body, but the door for that in terms of its definition is left open for the Advisory Council to come up with that. To answer Mr. Mun's question as well, and that is exactly the same. I think it's of vital importance that there must be robust public participation in the nomination process of these members who will be on that Advisory Council, as they will be the responsibility of ensuring that there is a non-government centered deliberation and development of an entity that can take the collective work for anti-corruption in a multi-sectoral fashion forward. We need to recognize that there are some functionalities when it comes to criminality and when it comes to criminal justice, which will always remain a government-centered focus. But when it comes to so many of the other areas, when it comes to the promotion of transparency, the promotion of ethical behavior and all of those things, that collaboration with the broader society and with the private sector is absolutely vital. And I think that is what the thinking was when we consulted also with the reference group, and why we had a panel external to government advising on these things, and to build that into the document that comprises the National Anti-Corruption Strategy. I hope that, without skirting it too much, addresses the fact that the Advisory Council is going to play an important role in the next 2 years in order to define the way we are going to deal with corruption in the future.
Tsheliso, can I just add something to that very briefly?
Okay.
Paul, your concerns are absolutely appropriate about independence and security of tenure. I'm not sure, but we can take it offline, why a statute could not grant that, and why it needs to be constitutionally enshrined, although I'm not opposed to it necessarily being constitutionally enshrined. But I think that at the end of the day, the independence of a body depends upon its reputation and its leadership. I can tell you that the competition authorities, certainly in the first 10 years of its existence, were not constitutionally enshrined, but nobody gave orders to the Competition Tribunal or even to the Competition Commission. And on the few occasions where that was attempted by ministers or whatever, they were very clearly rebuffed. And because the competition authorities developed a reputation for independence, their independence was protected. And I could tell you of a few Chapter 9 institutions that in parts of their lives have not been very independent of the executive authority. I think we all know who they are. And constitutional enshrinement or not, if you're prepared to take orders from the president or from cabinet ministers or from wealthy business people you're not going to be independent, no matter what your relationship to the Constitution is. So it's a more complex question than just where it's located. It's how it's led and the reputation and the standing that it acquires.
Thank you, David. I'm told Paul has a very quick intervention. Paul, colleagues will have another dialogue on this matter, so let us not exhaust everything. Just highlight the key issues.
Right. I
Paul?
think the short answer to the conundrum about statutory versus constitutional is that if you want to abolish a Chapter 9 institution, you have to command a 2/3 majority in Parliament. If you want to abolish a statutory body such as the Scorpions were, you only need a simple majority in Parliament. So the secure tenure of office, which is vital to the protection of the independence, is secured constitutionally by making the new anti-corruption body a Chapter 9 institution. Anything else, a mere statute, cannot get past the simple majority conundrum. And no matter who leads, whether they are good, bad, or indifferent, if the simple majority in Parliament is tired of the new anti-corruption body because it is upsetting its leading members, then you abolish with a simple majority. That really is the difficulty with a statutory body. Doesn't work. Thank you.
Thank you, Paul. Sunal, I guess there's a lot of food for thought, but certainly it's very clear there will be a need for further engagement on these issues from the perspective of Chapter 9 institutions, but also all other stakeholders. So thank you for the time you've given us, Sunal, and have a good day. So colleagues, we'll just take a 5 minutes break and then we'll come back at 11 o'clock, and then we'll start with Commissioner Chris Nissen. Thank you.
Thank you very much for the opportunity. And we look forward to robust engagement between the Advisory Council and the Commission, as well as members of the bar and of the private sector and civil society on this matter. Thank you very much.
Thank you. Welcome. So colleagues, we'll see you in 5 minutes. Welcome, colleagues. It's now 11 o'clock according to my time. We'll now hand over to Commissioner Nissen to give a presentation on the last slot before we get into general discussions. Commissioner Nissen, I hope you are ready. You are still muted.
Thank
Commissioner
you.
Nissen,
Thank you.
thank you.
Thank you,
You have the
Chairperson.
floor. You have the floor.
Thank you so much.
Thank
I was earlier in. I paraded the sky at Lulani, so I've been in it. But nevertheless, good morning, colleagues. Good morning, Chair. Mine is just a short one, and I hope that that I'll do justice to the Zondo Commission. While we appreciate the work of the State Capture Commission, I want to argue that its establishment was or is indicative of insufficient safeguards that are designed to mitigate against corruption, be it in the private or public sector. I also want to reflect on the previous days of the conference and reiterate that corruption has a negative impact on the enjoyment of human rights. We are past the stage of trying to prove the existence of the nexus between corruption and human rights. Corruption in both public and private spheres has human rights consequences, such as the reduction in the state's ability to respect, protect, and fulfill its human rights obligation. It affects the state's ability to fully realize human rights, and at the same time, the enjoyment of human rights is undermined. Colleagues, we've all been following recent developments in South Africa and elsewhere around issues of corruption and what some may define as a deficit in governance and accountability institutions or mechanisms. In the same vein, we have expressed our shock and outrage as the Commission. We're outraged and concerned about the negative impact that corruption has on the development of the people of South Africa and the region as a whole. While I was asked to reflect on sustaining the legacy of the Zondo or the State Capture Commission, at the outset, I want to reflect on the normative framework of the United Nations General. Sorry. One second, colleagues. Sorry. Sorry, reflection of the Zondo Commission. As I mentioned earlier, I'm of the view that the establishment of the Zondo Commission highlights some serious gaps in our accountability institutions. We have a number of oversight structures such as Hawks, Specialized Crimes Court, and legislation such as the Prevention and Combating of Corruptive Activities Act of 2004, which meant to build on the state's corruption architecture. Despite these anti-corruption laws and institutions, we are concerned by the effects of corruption on the realization of human rights, especially the socioeconomic rights in South Africa. This may be symptomatic of inadequate enforcement of anti-corruption laws in both public and private spheres. The question is then, how can we as a commission, together with civil society, assist the state in building normativity in the link between corruption and human rights? We propose that there's a proposal, perhaps in some spheres, of a establishment of a national alliance on corruption. But us as a national human rights institution, established in terms of the Constitution, the Commission must support constitutional democracy through close collaboration with bodies set up to fight corruption. Our mandate is designed to promote respect for human rights and a culture of human rights, promote the protection, development, and attainment of human rights, and monitor and assess the observance of human rights in the Republic. In responding to this challenge, we will be setting in motion the groundwork for the establishment of an advisory committee in terms of Section 11 of the South African Human Rights Commissions Act. Once established, this committee will be called the Section 11 Committee on Corruption and Human Rights Corruption and Human Rights. Section 11 of this Commissions Act creates an enabling environment for us to establish advisory committees on various thematic issues. These committees have traditionally attracted a wide range of experts. One of the opportunities we like to explore
Commissioner, you're faded.
Yes, sorry, I'm just, my problem is my public box is ringing, and I'm sorry, I'm using my telephone. Yeah. So these committees have traditionally attracted a wide range of experts. One of the opportunities we would like to explore through this committee initiative would be to advise the state on the implementation of the Zondo Commission's report once the Deputy Chief Justice has completed his work. This will require strategic cooperation and coordination of stakeholders. Our approach is based on ensuring that there's sustained adherence to the rule of law and that there is this important, follow up through continuous dialogue. The capacity of the institution starts with implementation of the recommendations. This is important as a guarantee of non-repetition. One may ask why we raise the issue of guarantees of non-repetition. There are human faces affected by the actions and omissions of the state through its officials. The realization of socioeconomic rights relies heavily on the role of the state. For instance, there are communities without safe drinking water in our municipalities due to corruption. I can raise a number of those. We welcome developments around the establishment of specialized mechanisms, but wish to reiterate that it's important to strengthen those that exist to ensure they are fit for purpose. My apologies for the interruptions, Chair. That is my contribution. Thanks.
Thank you, Commissioner Nissan, on your contribution and the thinking from the Commission side about possibility of setting up a Section 11 committee, an advisory body, which will help the Commission, to make a greater contribution in the fight against corruption. A mechanism which would also allow the Commission to invite all relevant stakeholders in this regard. So I will not really comment further on that, but maybe open then the floor for discussions, inputs. It's really, colleagues, more about the way forward. We've had this conference, we've had lots of inputs and great ideas. What is the way forward for all of us? In order to be more effective in how we fight corruption and its impacts on the marginalized and vulnerable members of our country. So the floor is yours. I hope I'll be able to see the hands, and Mabatu and other colleagues will help me in case I don't see all of them. Thank you.
I see a hand from Mr. Paul Hoffman. I don't know if it's from the previous session, as well as Mr. David Lewis. I'm not sure if they both left them on. I'll unmute Mr. Paul Hoffman and he will indicate. Mr. David Lewis has removed.
Okay, thanks, Mama.
I'm ready to wash up if you want me to.
Okay, Paul, you have the floor.
Yes, I think that what we mustn't lose sight of the fact that the rulings of the Constitutional Court in the Glenister trilogy, and in particular in the second and third of those cases, set a binding framework for the government of the country. What we have with the split of the anti-corruption work between the Hawks and the NPA is the Zuma administration's minimalistic approach to compliance with the requirements of the Constitutional Court, the binding requirements of the court in relation to the characteristics of our anti-corruption machinery of state. So it is not going to help to create a body which is as vulnerable as the Scorpions were to being closed down. And it's not going to help to try to work around the problems that exist in relation to the inability of the Hawks to actually fulfill their anti-corruption mandate. They are not a specialized body. Their job is priority crimes, and they have all manner of priority crimes that have nothing to do with corruption. So I don't believe that anybody who is in touch with the reality of the situation in South Africa sees the Hawks, who are at 46% of personnel capacity at the moment, as being part of the solution to the corruption problem we have. As far as the NPA is concerned, in the Zuma years, the NPA was compromised and hollowed out. Those aren't my terms. Those are the terms used by the leadership of the NPA. Hermione Cronje, who's been put in charge of the investigative directorate, has actually called her colleagues saboteurs. These are people who were planted there by the state capturers in order to see to it that nobody involved in state capture ever wears orange overalls. And so far, they've done very well. It's going to take time to repair the National Prosecuting Authority. They can't even fire a secretary who was over on the dark side, as you will have seen in the press in the last couple of days. Pinky lives on. So we cannot approach the problem on the basis that the NPA or the Hawks must be repaired and given the work that they are meant to be doing and aren't doing. That will take too long, and South Africa will fail as a state if a more proactive approach is not adopted. And having looked at it from all sides, the approach of accountability now, since 2011, has been consonant with that of Professor Kader Asmal, who was in the cabinet at the time and actually left politics rather than vote in favor of the demise of the Scorpions. The creation of a new Chapter 9 institution that is mandated to prevent, combat, investigate, and prosecute the corrupt, or maybe just grand corruption, is the way forward. And I sincerely hope that the advisory body and the executive branch of government get so far as to understand that tinkering with statutory bodies is just not going to work. Thank you.
Thank you, Paul. I've recognized Commissioner Leon Wessels to be followed by our colleague, Advocate Van de Merwe from Public Protector, in that order. Commissioner
Sio, then add Mr. Mans as the third person.
Okay, Dr. Mans, thank you. In that order, colleagues.
It appears to, okay, I've been unmuted. Thank you so much. Can you hear me, Tsidiso?
Yes, Commissioner.
Thank you. I think everybody involved in this conference should be applauded. And the reason why this conference strikes a chord with me is the fact that it is so inclusive, so overarching. And this initiative deserves appreciation, but I think it provides the Human Rights Commission and other partners and colleagues involved in this with a fantastic opportunity. Whether we like it or not, the Zondo Commission is going to take center stage for the next couple of weeks and months. So in a particular way, this initiative, if I may call this conference, and the possibility of further dialogues and initiative will allow everybody involved in this conference an opportunity to set the tone for the Zondo Commission report. To put it differently, if you manage to put together a report of this conference timelessly, it will signal to the South African public at large, but it is not only just the Zondo and his team that is thinking about corruption and state capture and relevant misdemeanors. A lot of other people are also thinking, and that you will be judging the report against the background of this conference report. So I wish you well in that regard. And I think what one must not lose sight of, and that is that there will be a lot of talk beyond the Zondo Commission report. And how will this conference and whatever structures flow from this judge that report? Because the one thing that will be a crime against South Africans if we allow the focus of that report to just dwindle away and that report to gather dust. If the report lives up to our expectation, fantastic, but we will need a watching brief. And if it doesn't live up to the expectation, a collective such as this conference should be in a position to say so. Thank you.
Thank you, Commissioner. Advocate van der Merwe.
Thank you, Chair. Yes, I've heard what Advocate Hoffman is saying, and I also appreciate what Commissioner Wessels is saying. And these are my views, because obviously we hear some of the things for the first time about the Anti-Corruption Advisory Council and the possibilities of a statutory versus a constitutional body. And you will know from the Forum of Institutions Supporting Democracy, have been battling with this issue of overlap and duplication of resources, access to resources on the part of Chapter 9 institutions for a number of years, taking into consideration how far back the ASMO report has been published, and they already issue of resources and duplication, and the fact that they add on resources to deal with certain issues were raised as a concern. But just as a general observation, in terms of the Constitution, Chapter 9 is endeavoring to establish bodies that have a common goal in strengthening constitutional democracy. And the constitutional aspect of, they have different mandates, different roles, which all underscores or have an element of the kind of culture and actions that are relevant to corruption efforts, like strengthening governance, strengthening financial accountability, oversight. All these things are part of the current framework in strengthening constitutional democracy. So looking at a body from and obviously it's very premature from a Chapter 9 perspective, one will see what is the exact value that this body, or what is the exact mandate area that this body will focus on in terms of these overlapping issues. If it's a prosecuting or a law enforcement element, then it's also moving on to the sphere of the NPA. So the council and whoever will be coming up with the eventual solution will have to carefully think what is the value in terms of constitutional democracy. And obviously corruption is one of the biggest threats to our democratic state. But they will have to find a specific place, because it doesn't only concern issues of accountability, oversight, and independence, but also access to resources, all the things that the FISD and the Chapter 9 institutions have been battling with for years now. To become another thorn in the flesh of the government is not going to secure the future and the operation of this body. So one will hopefully get a chance to make proper inputs in this, and hopefully from the FISD and the Chapter 9 institution side. But it will take very good planning and thinking to come up with an appropriate structure for this body. Thank you.
Thank you, Advocate. Peter?
Thank you, Chair. Yeah, I'd just like to say that this Human Rights Commission has actually taken a step in the right direction in terms of this anti-corruption stance. But South Africa's, we've got a leadership crisis, okay? There are 278 municipalities and 701 state-owned enterprises. There were only 18 clean audits in 2020. South Africa's got a corruption crisis. We've got a museum of truth and a library of evidence on this. There were no prosecutions in 27 years, and there were no prosecutions of any ANC or any government officials in that period of time. So this cannot be denied, disputed, opposed, or ignored. We need a national, they had a national action plan for xenophobia in 2015, promoted by the Department of Justice, but South Africa has centralized control. There's no separation of power. There's no lifestyle audits since 2017, as promised. South Africa's got a judiciary crisis. There's no political will to prosecute. There's no prosecution since the Zondo Commission was established. And South Africa has a prosecution crisis. So a national action plan for corruption has failed. There are certainly many interested groups out there, critical thinkers, strategic planners, and concerned and thoughtful citizens from all sectors of society that are concerned about having they don't want revenge, but we certainly need restorative justice. Now, South Africa's got a systems crisis. There's no control of the investigations, the National Prosecuting Authority, and it needs intervention. There's no oversight committee, and the South African Police and the Special Investigations Unit, they have to report to the Office of the President before these issues are actually even investigated. That's far too much power for one person to have in this country. So we need a second house, and we need a national action plan. But we haven't been idle. In 2019, after junk status and recession, we established a peace commission, quite important, because we basically need peace from this lawlessness, violence, civil labor, and rest. And we also need a solution to the crime. We've got junk status. We need social growth. We need a solution to corruption. We need food security, poverty relief, and we need that investor confidence. We need a solution to restorative justice. These people who are actually prosecuted, they need to pay back. All those interested parties that have actually done extremely well by plundering the public purse must be brought to justice. We have what's called the Solomon Project, and this is a catalytic project. South Africa has been promised all these pie crust promises through 6 State of the Nation address, State of the Province address, and these are just empty pie crust promises. So the KZN Growth Coalition also has a plan, and the Office of the President has a plan, but none of these plans are actually implemented. Now, the catalytic projects are game changers. The Solomon Project is a game changer. Now, these are supposed to deal with agriculture, agri-processing, renewable energy, job creation, skills development, technology enterprise centers, and these demand finance, infrastructure, and service delivery. And they even have the support of the banks. The top of this list was crime and corruption. So the Solomon Project is totally focused on not only finding a solution to this corruption, but finding these people, prosecuting them, and convicting them, and then locking them in a room and throw the room away. We have to be totally committed to this process. It can't be managed by the same people who have committed the crimes or allegedly committed the crimes. Let's be politically correct. But we need people with a passion. We need those thoughtful, concerned people. As Margaret Mead said, never doubt for a moment that the world cannot be changed by a small group of thoughtful, concerned and dedicated people, because it's the only thing that ever has. So this is not a hobby. This is not a hobby. We've been at this for a long time, but at least we have the research. We're no better than any other concerned group, but we want to make sure that we actually have the right partnership, we have the right interest groups, and we've aligned ourselves with the right people who have got solutions and not just the issues and tissue or empty promises. Thank you, Chair.
Thank you. Any more hands? No.
CEO, I'm not sure if Commissioner Wessels has his hand from the previous input or if he wanted to speak again.
Commissioner Wessels, is your hand down or up?
Hey, it's supposed to be down. Sorry.
Okay. Colleagues, then, if there are no further inputs, then we will then come to the last part, which is the closing remarks of the presiding officer for this session, and that happens to be me. So I would like to start by saying, colleagues, it is very clear that corruption is a threat to our constitutional democracy, is a threat to the advancement of human rights, is a threat to the rule of law, is a threat to our economy. And therefore, bodies like us in Chapter 10 and 9 of the Constitution, which have been established to strengthen and protect our constitutional democracy, have to step up. And hence, I guess, why we partnered with the public protector to start this initiative. Also acknowledging that, we could have done better in the past 25 years of our existence together. And maybe things wouldn't be where they are today if Chapter 9 bodies, particularly the Human Rights Commission and Public Protector, have been playing a better game than we have been doing. So it is really crucial that those of us in Chapter 9 and Chapter 10 really come to the party and find ways in which we could work together with everybody else to make sure that, we do effectively fight the scourge of corruption. And as we have said, it unfortunately affects the most vulnerable, our children, our grandmothers, people in rural areas, those without the power to fight and resist this corruption. So in this regard, we are quite grateful for your support for the past 3 days and for your valuable contribution. It is also important, colleagues, that despite all the monies which have been put into the Zondo Commission, far more than what a body like the Human Rights Commission even gets a year to do its mandate, that the Zondo Commission's report and recommendations do not disappear in the twilight of our normal situations. That whatever comes out of that report should be used to effectively address the challenges. And therefore, like we said yesterday, we really appreciate the contribution of the public protector for getting us the Zondo Commission. Of course, people will argue that, there are agencies which could actually have been doing this thing. There might have been no need for the Zondo Commission if those who have been entrusted the responsibilities and the power to fight crime and fight corruption were doing their work effectively, the NPA, the Hawks and SIU and everybody else. But here we are, we have the Zondo Commission. And as Commissioner Wessels is saying, it will be a crime if we let the Zondo Commission and its recommendations disappear. And therefore, it's also up to us as a collective, but also as chapter institutions to ensure that we sustain the work which has already been began around issues of corruption and the Zondo Commission, and that we commit ourselves as a Human Rights Commission in partnership with Pulp Protector, but also other Chapter 9 and Chapter 10 bodies. We'll raise these things in our engagements to say, colleagues, how best can we work together in this? Now, the third point, of course, is the announcement by the President during SONA that there will be a new anti-corruption agency, which will be accountable to Parliament. And now we're here that it might be a statutory body or it might be a constitutional body, maybe in Chapter 9 or Chapter 10, we'll see. But there is really a need for us to engage with those behind these ideas to see exactly how this will work. We also heard that in SONA that 1.8 billion rands will be assigned to this new initiative. That's a lot of money, and maybe that money should be put to good use. But again, we need to engage, as Dr. Mann, as well as Advocate Hoffman was saying, that how is this body going to fit in the current state of affairs, in the context of the Kara Asmal, in the context of strengthening constitutional bodies which are already in existing, which can also contribute much better in fighting corruption. So there's definitely a need for us as Chapter 9 institutions to engage with government so that we just don't again create bodies after bodies which really don't go anywhere. Last year we had an engagement with Professor Mahoba. He made a very funny statement. He said, you know, when there's a problem, politicians simply throw new laws and new bodies and new policies, and nothing ever happens again. So we really need to be careful that the ideas around these new agencies are not just a passing phenomena to try and appease the public that something is being done around corruption, when there are existing mechanisms, which if better strengthened and better supported, could really make a massive contribution in the fight against corruption. So we really want to thank you again for being here. And we as the Commission, we're committing ourselves that we'll continue to engage with yourselves towards this mission of a better South Africa, free of crime, free of corruption. And therefore, we'll quickly try and put the report together. And there are a number of issues which we have identified, which have to happen going forward. There's definitely a need to look into the whistleblowers legal framework to see how better we can encourage our own people to become whistleblowers against corruption, but also to ensure that they are better protected than the current regime does. And therefore, we'll be looking to this to see exactly how we can strengthen this, whether it requires amendment of the laws or whether it requires a change in practice and behavior by those who are supposed to protect a whistleblower. You know, just thinking now that maybe we should actually, following what David Lewis was saying, that maybe it should be an honor to be a whistleblower in our country. And therefore, maybe we should consider, having an award or recognition for whistleblowers in our country, the good ones, not those who are trying to save their skins because, they've been involved in corruption, but ordinary South African men and women who care about their country and will say no to corruption. And at a great risk to themselves and their families, do stand up. We really need to treat those people as heroes and heroines and find the mechanisms of how we can better protect themselves. And therefore, this is also a challenge to us as Chapter 9 institutions or Chapter 10 to say, how do we also assist in this regard? And of course, we'll also have to consider litigation if necessary around this. But there's also a need, colleagues, for us as a collective to really raise greater awareness amongst our people that corruption is not good for our country, that corruption goes against every value of our country. It undermines even the future of our children. And therefore, we need to do more as a country to say no to corruption, and that those who are stealing our resources, who are stealing billions of monies, which would actually provide better education, better food for our children, and a better economy, basically face the consequences and basically go to jail. But more importantly, those looted resources must come back. So we should really commit ourselves that those who have looted our resources will have to pay and return those resources. They belong to us as a collective, as a country. They are here to advance our country, to strengthen our constitutional democracy and human rights. And therefore, we really have to issue a huge resounding no against corruption. So colleagues, with these words, I really want to thank everybody again, and I want to thank our partners, the public protector, and all the speakers who took their time to prepare and make contributions, including those who came at the very, very last minute, sometimes 5 minutes just before we start due to other challenges. But we also want to thank the Minister of Justice and his team for availing themselves and supporting this conference. I also want to thank my commissioners, our leaders, who also gave us a space to be able to host this conference and take time from other work of the commission to do this. I also want to thank my colleagues in the commission from our IT guys, despite the problems and angry calls from the CEO, but also as other colleagues who helped to put the program, identify the speakers, so that we can have this conference. I also want to thank all our staff members who are behind the scenes to make sure that the commission continues to function for making this conference an eventuality. So colleagues, we do undertake as a commission that we will continue this fight, because we have made the issue of corruption and human rights part of our strategic objectives for the next 4 years. And therefore we'll be judged as a commission by how we basically give effect to this strategic objective and how we give effect to our mandate of promoting and protecting human rights in the context of corruption. So I really want to thank everybody for this. So I would like to hand over to Commissioner Nissen. I hope he's still here, who was the political head of this initiative, just to say a few words before we close. Commissioner Chris Nissen, I hope you're still here. Commissioner, we can't hear you. Okay. If Commissioner is not here, I will ask the next Commissioner on my screen. Commissioner Gam.
Am I unmuted? Yes, thank you very much. Now, I also would really like to thank everyone who participated in this very important conference, collaborative effort by the South African Human Rights Commission and the Public Protector. I think a lot of very important ideas came out of this conference, and it will now be for the Human Rights Commission and the Public Protector to put all these ideas in a proper document that we can then see how we can take some of these matters forward, discuss it maybe a little more between us and the Public Protector, and then make very firm recommendations also to government in this regard. I think one of the issues specifically that's also very important and that should be reflected in such a document should be the overhaul of the witness protection program, which has been mentioned, and then obviously this anti-corruption body and how it should function and where it should be situated. But thank you very much to everyone. As the CEO pointed out, corruption has a very direct impact on human rights, as we all know, especially also on socioeconomic rights. We were discussing yesterday also to see specifically how we can tackle problems relating to my focus area, education, corruption and education kind of matters. And we will certainly, make sure that we start focusing on these kinds of issues more. Thank you, CEO. Thank you to all the participants.
Thank you, Commissioner. Thanks to everybody else. Please enjoy the rest of the day and see you soon in another dialogue. Thank you. Bye.